right, everybody. Thank you very much for joining us today. This is Business Opportunities and Legal Challenges for Content Creators and Game Devs. So really appreciate you all joining us. This is a great area to be in. This is also part of the Georgia Game Developer Association's annual Siege Convention, Southern Interactive Entertainment and Game Expo. Woo! And we look forward to you continuing with us through the weekend. Tomorrow we have a bunch of game devs talking about hacking their game dev life, the secret hacks they've learned to make it go effectively. And then on Sunday we have Unity 3D coming in to talk about the new Unity engine they just unveiled in Barcelona, the Unity 6. They showed off at Unite in Barcelona last month. So, I'm very glad you all could join us for this panel today. And let's go on down with introductions. Should we start on the far right?
Sure, be happy to. Hi everyone, my name is Beth Moore. I'm an entertainment attorney. I've been friends with Andrew for a long time, and although my practice has historically focused on music, film, television, book publishing, and other more traditional creative arts, I recognize the need for competent legal counsel in esports and gaming and content development. So I'm happy to be here to kind of provide the legal perspectives on some of the business topics we'll be talking about, and hopefully convincing every one of you that at some point in your life you should engage legal counsel for your creative business. And that's why I'm here. So nice to meet y'all and looking forward to the discussion.
Awesome. Hi everyone, my name is Ash. I stream on Twitch as AshSaidHi. I am one of the Twitch Women's Guild leaders. We just started that. Thanks. And I'm also a Twitch ambassador, and I mostly broadcast retro games and a lot of Nintendo games on my channel, and I've been streaming since March of 2019, and I'm here to lend my perspective as a creator and share some of the things that we go through. So hopefully through my experiences you can learn a little bit about how to navigate some of the issues that we face together.
Excellent. I am Andrew Greenberg. I'm the Executive Director of the Georgia Game Developers Association. Find us at ggda.org, Georgia Game Developers Association. I've been a game dev since 1990, back when most of you were just graduating college. So, on my left.
Hello everyone, I'm Tygarlily. I have actually been a freelance creator in the Atlanta area since 2018. I was hired to manage creators 2 years ago, and so my perspective here for everybody is what it's like being a creator, working with contracts, and then also being a manager and working with creators, contracting them.
All right, so now you know about us. We would like to know about you. How many of you are content creators? Excellent. How many of you are game devs? Excellent. How many of you are both? Okay, there we go. All right. So that's good to know. We got a good mix of both. I think a lot of the lessons we'll talk about today will go in between. We'll try and have some time at the end for questions. The way we're going to set this up is each of us creators will be talking about situations we've encountered, how we've structured these opportunities, and then Beth is going to come in and say, if she was advising us, how she would have helped save our butts. So we're going to start with AshSaidHi.
So recently I did a sponsorship for a major game brand, and pretty much, well, not just recent, but pretty much every game sponsorship I have to engage with, there is a contract that we have to sign. And as you know, contracts have a lot of pages to read, a lot of legalese, maybe some things that are written in plain English but you still don't understand because they ask for different things. So for me, it's understanding, when a contract says something like, oh, we want to use your content in perpetuity, or we want to use it for a certain amount of time. What does that mean? Should I be paid a certain amount for whatever usage there is? And, what are basic things I should look for that maybe red flags in a contract, or just maybe things that I should just pay attention to. So that's probably one of the issues that I deal with frequently as somebody who does a lot of sponsored work.
You want to talk about some of the specifics you encountered, and then we'll turn to Beth?
Yeah, a lot of times it's usually like usage, but mostly it's like whenever I have to work with a game company, they'll say things like, don't disparage the company, don't disparage or don't talk about competitors, or use very certain language and avoid talking about brands that are not this or not within the realm of gaming. Like I did one recently where they were like, don't allude to being obsessed with the game. Like you have to be very careful about how you present the brand. So those are really important things that I have to keep in mind. But yeah, just things that I should probably look into, like, oh, is this something that I can ask? I guess that's the biggest thing too. If there's things in the contract, like can I ask questions or say yes to some things and say no to some things? Like how does that work?
Sure. So this is a perfect hypothetical scenario of someone who might come to me with a contract and say, I've been offered this deal, I don't understand this language, can you help me? And the first thing I'll say about contracts, particularly the good ones that are drafted by other attorneys, is that although they are written in English, they do not mean what you think they mean. There is a lot of industry terms of art that are used in a contract that simply mean different things in colloquial language. So even though, again, it's in English, it really is an entirely different language and one that I am fluent in and can translate for my clients. Those boring legalese contracts that usually end up at the end of the contract that your eyes just kind of glaze over, those are oftentimes the most important ones, right? And they're difficult to decipher. Trust me, I know, because there was a point in my life where I was not a lawyer, and I spent years learning how to decipher this language and what it means in real life. And there can be some doozies, buried into, page 15 of your contract. Those are the ones that my eyes are trained to find. Because when, say this video game company offers you a deal, they're not offering you something that's in your best interest. They're offering you something that is in their best interest, and it is up to you as the recipient of that offer to help balance it out. If you just sign it as is, you are essentially agreeing to the best possible terms for the person on the other side of that deal. I can give you some examples of the things that I would look for in a deal like the one that you may have received. Number one, how long is this contract going to last? There should be a clear term of use of whatever rights you may be granting. There might be specific deliverables in terms of, maybe how many times you have to go on Twitch and, broadcast, the game that is being, sponsored in your videos. We had a conversation earlier about the do's and don'ts of what you can and cannot say. Oftentimes there can be something called a morality clause where, if you act up in public in some way or get arrested or are, accused of a crime, like these are all things that may allow the video game company to revoke your contract and maybe even in some instances require repayment of the fees that they may have paid to you up to that point. Let's talk about fees. The fee schedule should be very clear, and usually they are based on the deliverables schedule. Well, sometimes companies want to pay you 30 days out or 60 days out or 90 days out. Well, you got me, I'm going to make sure they pay you at least some portion of that in advance, right? Even just receiving the money can sometimes be a challenge, right? More obscure things.
What? I'm always getting paid like net 60. What?
When you get paid.
Right.
Well, yeah, when I get paid.
Because that's in the company's best interest, not your best interest. But everything is negotiable, right?
Remember that phrase. It is true. Everything is negotiable.
Even when they tell you it's not, they are lying.
Okay, what about when they say we want the stream to happen in X amount of days. Normally they'll give you the contract and then they'll okay, we need you to stream it next week or in a couple of days, whenever this launches. I had one where they literally gave me the contract the day before they wanted the game streamed. That's not enough time for me to look and consider or even consult
I don't know,
with
because
somebody.
for me, when I reach out to people 2 months in advance, because I want to know you're there for me.
Yeah.
I want to make sure my schedule is set and you are ready, and then I'll give you maybe a week beforehand to cancel.
Yeah. Yeah.
Well, duress is a way that some people get their way, right? If they say, hey, you've got 24 hours, there is not enough time in the world to engage legal counsel under those conditions. right? So, I mean, it is kind of a strategy that they employ to put your back up against the wall so that you really don't have an opportunity to negotiate anything in your own favor. So, to me, that is an enormous red flag. I get these requests all the time where someone brings me a contract and say, yeah, the other side wants us back by Tuesday. And I'm like, why? Unless you're up against a time constraint, which oftentimes is created intentionally, then in my experience, there's almost never an emergency in the entertainment industry unless it's due to somebody else's mistakes. Anyway, I could go on and on, but
No, I'm just like everything.
I love your question. I love your questions, Ash, because
Everything you say to me is like literally like the things that I go through every day. So just I feel like selfish is like asking, but it's like it's exactly what we all face as creators, right? So it's like they'll give you that's exactly what happened. They gave me the contract like the day before I had to stream, and then I would have had no way. And when I responded to them, they were like, well, we can't change anything, like this is just how it is.
And you have to decide if you want to accept working under those conditions.
Okay.
That's really it.
I guess the biggest thing is people feel FOMO, or like, if I don't accept this opportunity, I don't know when my next opportunity is gonna be.
Well, there's an opportunity cost for every contract too, particularly if you're dealing with anything that requires any level of exclusivity. This is a very specific question I get with a lot of clients. What does exclusive mean? Well, we hear that term, in our day-to-day language, where we all think we know what it means, but contractually it means that you are excluded from participating in certain other activities. Like, for example, if you are doing promotional work for game company A, and there's an exclusivity clause, that means you cannot do any, sponsorships or anything, or any activities with video game company B, C, D, E, F, and G. Right, that's an opportunity cost, right? And you have to balance, is that exclusivity with company A worth missing out on opportunities with all those other companies?
Let's talk a little bit more about both exclusivity and terms. So someone comes here and says that they want rights in perpetuity throughout the known universe. What rights is she giving up?
Yeah.
And what the heck does that mean to her?
Mm-hmm.
Yeah, anytime I see in perpetuity in a clause, and I'm going through it, I highlight that. I make sure to go back and talk to my client about it. It's not necessarily a bad thing. There are plenty of times where granting somebody perpetual rights, meaning forever and ever amen, is either necessary or appropriate. And sometimes it is wholly inappropriate to grant somebody perpetual rights to something that you have. And usually we're talking about name, likeness, and image rights. Right? The ability for video game company A to capture that Twitch stream that features your face, right, your name, and then attach that to their brand for an indefinite period of time. If I'm representing the creator in that regard, there are two ways that I look at that exclusivity clause. I say, okay, number one, does the price point match the level of rights that you are granting? Because if they're requesting perpetual rights from you, there should be some good money attached to that. Right? That's a premium price, in my opinion, in most cases. The other thing that I think about is, well, do the rights actually have to be perpetual? Can we limit them, in accordance with the relative pay scale for that contract? In other words, if you do really great work, maybe you say, hey, you have the right to use my content, my name, likeness, and image for a year. And if that video game company A wants to extend it to 5, 10, 20, or perpetual amount of time, then they should pay a premium for that. So I've also built in like tiered fees based on what the other side's desires are to get out of the contract. So you want to use my name, likeness, and image for a year, it's going to be $1,000. You want to do it for 2 years, $2,000. You want to do it for 10 years, it'll be $5,000. Give them the option. But you do not have to settle for perpetual. That is just the baseline proposition that meets the other side's highest needs, but it doesn't mean you have to agree to it.
Let me bring up another topic I think Ash should be considering, and that's termination clauses, both ways. And I see creators, they'll have something where the company will say, we can terminate if these things happen, and there's no like thing for you to terminate the contract. So Beth, do you want to address that a little bit?
Sure. So termination is the right to end the contract, right? Maybe that right belongs to one person in the contract, maybe it belongs to both parties in the contract. But there are usually stipulations in any contract that will dictate who and under what conditions can one of the parties to the contract say, I'm done, I'm walking away now. Usually it's the person who's paying the money that has the right to terminate under certain conditions, or maybe even under any or no conditions, right? So, if you sign a deal with company A and 2 weeks later they say, actually, we're going to cut this, they will probably have the right to do that under even a normal negotiating situation. For you to be able to terminate it, yeah, there should be something in there, but there should be some language in there to protect you in the event that you choose to terminate. For example, if game company A, does something that violates your terms, right? Whatever that might be, we can get creative with why you might want to terminate your relationship with video game company A. What are the consequences of doing that? Well, number one is you probably have to pay back any money that you've received. I would hope and expect that there would be no other penalties to you beyond that, but it might also bar you from being able to work with that company, for the foreseeable future if you terminate it, especially when there has been nothing that they've done to cause that. But every business relationship, just like most romantic relationships, will eventually come to an end. So it's part of the purpose of a contract is to think of it as like a prenuptial, right? What's going to happen when the two parties need to go their separate ways? And those are absolutely some of the things that we negotiate and think about. When you enter into a business relationship with somebody, again, kind of like a romantic relationship, you look for the best, right? You're really excited. You're like, oh my God, this is great. I'm advancing my career, making money. I'm going to be famous. But eventually, that relationship is going to either come to a natural expiration or it's going to go wrong. And being able to predict in advance, what that process is going to look like and have a say in how that goes down can be very beneficial.
I have a question. Should creators contract a lawyer for like every contract that they look at, or is there like a baseline thing that they can learn to maybe look for, and then if they see something questionable, they call you all? Like, how does that work?
Good question, and then I want to make sure that Tygarlily gets a chance to ask some questions too.
Yeah,
but
sorry.
I'll answer this one. I want each and every one of you who may be in a position, either now or in the future, to engage legal counsel to know that you can do what literally every other business does, and you can pass the cost of your legal counsel onto the consumer. Okay? What I mean by that, let me give you just a really rough example. Let's say video game company A and says, I'll pay you $5,000 to do, 3 separate, Twitch streams of my game. Great. You need to go to a lawyer, right? The lawyer is going to cost you $1,500, right, roughly, to review the contract, redline it, negotiate it, rough numbers here, okay? That doesn't mean that your $5,000 payment is now reduced to $3,500. No. What you're going to do is you're going to go back and you're going to negotiate that your fee is now $6,500. Because that's what's required in order to get $5,000 in your bank account. Pass the cost on to the consumer. The video game company that's hiring you is your client, is your consumer. Pass the cost on to them. Or be prepared to take the hit in exchange for knowing that for in perpetuity, your rights are protected. It is worth it, I promise you. I do it all the time where we bump up the fee in order to cover the cost of it.
And I'll throw out the why you should do it every time argument. And this is true life story. I was the original developer of a game called Vampire the Masquerade. We did a bunch of other games, werewolves and so forth. And we licensed another company to do a different version of it. And so contracts got passed around. We agreed they're going to license a version of it. Gets up lawyers and finance, and it's, no, you're actually giving all rights to the World of Darkness to this other company. It's not just licensing. So, I mean, you have to be careful. Are they actually asking that they're going to have ownership of your brand? Are they going to own AshSaidHi? So you want to either be taking a very close look yourself or have someone who can take a close look for exactly that kind of language. So You want to keep on the content creator?
Yeah, I want to hear your story.
Yeah, as a, maybe I would like to hire a creator. So this is where this question is coming from. And I would like them to help me make a YouTube video. And this YouTube video could or it could not be a big hit on YouTube. Maybe it hits 1 million views. Maybe it helps grow the YouTube channel. When I'm contracting this creator and I'm setting a set price with them, I'm like, hi, this is your deliverable and this is how much I'll pay you for it. Are they okay when they sign that contract, that's how much they pay? I'm asking should I approach this with somebody when it comes to YouTube, and it could be content or entertainment that grows.
So you're talking about, you mentioned earlier you're a manager. You're talking about management agreements with your creators?
Mm-hmm.
Yeah. So I was actually an artist manager early on in my legal career as I was building my practice. So I'm very familiar with the kind of dynamic of the artist-manager relationship. It is one of the, kind of the more intimate business relationships you will have, depending on the role and expectations of your manager. The way I like to think of managers is like they're your best business friend, right? And, their success is your success. But what I tell my artist clients, and I represent managers too occasionally, is, I tell them like, look, your manager is your best business friend, they're on your side, they're your #1 fan, but they're also in business for themselves, okay? They're doing it in conjunction with you, but they are also still looking out for themselves at the end of the day. The only person who is truly on an artist's side 100% of the time is their lawyer, because ethically we are always required to put our clients' needs ahead of our own. But other than that, a management agreement will, like kind of the larger subsets of a management agreement come back to some of the things we've talked about already. The term, how long is it going to last, right? I've seen management contracts, last from one year to 3 years to, there are various provisions that allow the parties to extend the term. Coming back to termination, what rights do the manager and the artist have to terminate the contract? Here's a preview. Normally the manager has the right to terminate the contract at any time for any reason or no reason at all, but the artist would have to have certain things that might happen that would allow the artist to, essentially give the manager the boot. The commission rate, right? How much is the manager going to get paid? Usually it's a percentage-based commission. I've also dealt with management companies that wanted to be paid a monthly fee plus a commission in some cases. Post-term commissions, right? If Tygarlily helps somebody, get a big sponsorship deal, but that sponsorship deal lasts longer than the term of her management contract, should she be able to continue collecting a commission on that because she originated the contract while she was the manager? The answer is usually yes, right? Because you wouldn't have had that deal or even the renewal of that deal if she hadn't done her job as the manager. I think about things like, who's going to control the purse, right? When, you're managed by Tygarlily and you get paid for a deal that she helped you get, where does that check go to? Right? Some companies will bifurcate it, send her 15% cut, send you the rest. Sometimes it all goes to the manager, she pays you. Sometimes it goes to you and you pay the manager. These details matter. So they are always negotiated in deal. Oh, and I should add another version of this is that maybe Andrew is serving as the business manager, so he gets to check and splits it between the two of you, right? While he takes a little 5% off the top, right? So, no two contracts are the same. People think that I just pull templates all day long and fill in the blanks. That is not the case. Every deal is different. Every deal matters because the people associated with that contract matter. So, yeah, management contracts can be very important, and they're highly customized to the two people involved in that relationship.
Okay, cool.
And I'd love to hear your story of what are you looking for in folks in your hiring? I mean, be general and get into specifics of it. And what do you think they're getting from you?
When it comes to me, I do live broadcasting, so I'm looking for someone with a big community who is engaging and can actually work with top brands. They have to be professional. So you'll run into, I run into Ash, and you're just having a great time. You're being PG-13. I'm like, this is the right energy I need for an Xbox promotion that's coming up. right? And that's what I'm looking for. I'll bring you over, and then we'll start negotiating and talking and building out the contract together. I like to talk. And at any time you hear a red flag, please tell me. But I want to be open and communicate, and I'll spend a lot of time working on this with you to make sure that I'm meeting what you need and what who I'm working with needs. And in this case, it could be Ants Online. And then once we've established that, then I'll send you the contract, and if you want to go to your lawyer with it, you can, and then you can come back. So that's what I'm looking for, and it's all based on what the project is asking of me, right? And what you're looking for. So you love Black Ops. I don't know if you love Black Ops, but let's say you love Black Ops.
Okay. I do now.
And that's coming out at the end of the month, and I need somebody that actually appreciates that game and their community loves that game. So that's what I'm looking for when I'm looking for my creators. And then we start getting into the negotiables.
Do you ever vary the payments based on sizes of audience, how many views it gets, et cetera? Is it
Yes. So rates are based on your community and how well your quality is when it comes to the content. So do you have that 4K camera? Are you able to meet what we're looking for when it comes to metrics? And that's how we size the rates depending on that.
I love hearing that, because in games, of course, it's royalties, and my lawyer, who represents a lot of Grammy Award-winning, million-selling artists, says the difference between my royalties in game industry and his music one said that I actually get my royalties, which is notoriously bad on the audio side. All right, let's dig a little bit more into the game side. So in this part, we're going to focus a little more on the intellectual properties of it, which these both have. They are essentially their own intellectual properties. They are their own marks, AshSaidHi and Tygarlily, but they also have all this content that they owned. Now, for game development, we do the same, and it gets even crazier trying to figure out what we're licensing, what we're keeping, etc. So obviously, we are creating a trademark in the title of our game. There's copyrights to certain things we're creating as well. So the new studio is creating a whole universe, a game that goes with it, and trying to perhaps create a piece of fiction to go along with it. They say, what are we actually creating? What do we actually own? We go to our lawyer with them, and they say, what the heck are we doing?
So I guess that's for me. So let me step back for a minute, and if you were here for our legal panel last year, this might sound familiar, but what does intellectual property even mean? Because again, it's a term that we're all kind of loosely familiar with, but who can really define it? So let me help you out. Intellectual property is a blanket term that means 4 different things. Intellectual property includes copyrights, trademarks, patents, and trade secrets, okay? The 2 that is most applicable to this audience are the first 2, copyrights and trademark. Copyright is a body of law, Title 17 of the U.S. Code, that protects creative works. Original creative works that exist in a tangible medium. In other words, it has to exist in some form. You're writing a book, start to write the book. Now you've got copyright protection. You're creating a game, actually create the game, not just an idea in your head, but create it, and that creation has copyright protection. Meaning, somebody else can't come along, steal your work, pass it off as their own, because that original work of creation that exists in this world belongs to you, and you have rights to that work. Copyright means the right to make copies, okay? And by copy, I mean literal copies or distribution or public performance. You know, it's not really just one thing, it's a bundle of things. Like, you own a copyright to a piece of music, you have the right to print it on CDs, put it on Spotify, you know, sell it on Apple iTunes, play it in a restaurant. Like, you see there are multiple ways to exercise copyrights in multiple ways to protect that. Trademark is a source identifier, right? Our gentleman in the front is wearing a ramen noodles outfit, right? You see that, you immediately know what brand that's associated with, right? You know, you pick up a bottle of Coca-Cola and you know exactly what the quality of that product is going to be, right? Because of the source identifier on the packaging, right? That is a trademark. And trademarks can be a name, right? Just the name Coca-Cola. It can be, you know, the image associated with that. So again, coming back to our hometown brand Coca-Cola, it's that specific shade of red and that cursive white font, right? All of that is a trademark. The name of your game may qualify for trademark protection. More likely what's protectable, or what's more strongly protectable is if you have a series of games, right? The title of that series can be protectable as a trademark. Here's a literary example. You know, when the first book of Harry Potter came out, the title was not protectable, but once the second book in the Harry Potter series came out, now that's a trademark, okay? So there are different rules that apply to different industries and how trademarks are applied, but if you want to be able to name your game and then prevent anybody else from naming their game the same way, then trademark protection is going to assist you a great deal. You know, we could, you know, in another panel we can talk about how patents protect the rights of inventors and trade secrets protect things that are held confidential, like the Coca-Cola recipe, right? That's a trade secret. You know, but the first two are what we'll focus on now. I'm happy to address any specific questions about those two
So what
things.
we'll learn to, I go to you. We've got a series. Well, not going to be ramen the game. Let's see. I can't call it DreamHack the game either. All right. So AshSaidHi is now in game dev.
Okay.
So she's got AshSaidHi the company. She is publishing the game AshSaidHi, and it's going to be the first part of a long-running series with the Ash character,
Okay.
who is not the Walking Dead Ash. So, what can she do? What would you do for her?
Yeah, so, you know, the first thing I would look at is who created the game itself, right? Because, again, rights are granted to either the creator or the person who commissioned the creation, right? So if Ash creates a game, creates a whole universe of characters and storylines and plots and puzzles and all of that, she is the creator. But there's another scenario here, which is, let's say I'm a game dev investor, and I know that she's got great ideas. I say, hey Ash, can I hire you? I will pay you to create a new original game for me. Right? Now maybe I give her some ideas, or maybe she pitches me ideas, it doesn't matter, because at the end of the day, when she's done, that creation that she made, that game, will belong to me, because we have signed a contract that says that whatever Ash creates doesn't even transfer to me, it originates with me. I am the owner of it from the get-go, and that's what we call a work-for-hire agreement. So if there are any game devs out here, and I know how these things tend to come about. You're friends with some game devs, right? You're sitting around, you're having a good time, you're like, we should create a game, right? So a bunch of friends come together, pool their ideas, and all of a sudden they've got a really cool game on their hands. Maybe some of the ones out here in the indie playground. Well, that creates a scenario where you may have multiple people claiming ownership rights over a game. And it's not even usually under the banner of some kind of LLC or something. It's just 5 individual people having put their hands into the pot and created this game. Well, that means they all have co-equal copy rights to that game. This is, from an IP perspective, a potential nightmare scenario. Because, you know, if Andrew the investor shows up, you know, and, you know, Ash and I own a game together, and he says, and let's throw Tygarlily in the mix too, right? All 3 of us created this game as friends. We created it. It was a hobby, but now it's really catching traction, right? Andrew says, hey, I'd like to buy out the rights, or I'd like to invest in it. Well, you know, at that point, he would be investing in something that does not have a firm foundation. Who has the right to even negotiate this? Is it me? Is it all 3 of us? If all 3 of us have to hire our own attorneys, and then Andrew's got his attorney, oh my God, this is a really expensive proposition all of a sudden. So, you know, the ideal way to go about this, and you can course correct even after the fact, is to assign the IP rights under a mutual agreement with all of the creators, saying we're going to assign the rights to an LLC that we are potentially going to co-own together. Now the LLC is the entity that will negotiate any third-party contracts, including with an investor, with a distributor, you know, with whomever. If you do not have that clear IP chain of title to who actually owns the game, gets to make decisions about the game, that can deter a lot of opportunities, because it can become an IP challenge for the person trying to participate in that game with you if you guys, as the creators, don't have that worked out already.
And let me give you a specific real-world example of this. We did a game in the late 90s, 97, called Warhammer 40K Final Liberation. So it was a project between us, Holistic Design Incorporated, Games Workshop, who owns the Warhammer license, and a company then around, a game publisher called SSI, which was big in role-playing games and strategy games. So we made the game, but obviously we could not own the rights to the universe. It was owned by Games Workshop. We weren't going to be distributing it, etc. But our lawyer made sure that we retained all rights to our game engine and the assets that we created for the games that were outside of the universe, the technical assets. And that game disappeared, went into abandonware for a while, but it came out about it that got to start being distributed again in about 10 years. Whole new owners, SSI was long gone. And we could go back to them and say, hey, you owe us royalties because we still own that engine. You can't just stop paying the royalties on this. And sure enough, we still get royalties on this even though we're not involved in it online because our lawyer had the intelligence to say, this is what you own no matter what. So strongly recommend you keep an eye on that. Okay, I think we're having a lot of interested eyes out there. We are more than halfway on through the...
I should have one
Oh,
question.
keep up your absolutely.
Sure.
I have one after Ash.
Should I, as a creator, create some LLC for my name, like AshSaidHi? Like, we were talking about this a little bit earlier, but like, as a creator, like, what owner or usage rights do I have? Like, if I create like AshSaidHi, like, what should we consider with that?
So it's a good question, and you know, if for the audience members, if you are engaged in some activity that you are commercializing or that you're thinking about commercializing, then you may have a good reason to set up your own business to separate what you're doing from a commercial perspective versus how you operate your personal life. Okay, and there are a couple of reasons why you might want to do that. The first is liability, right? If an LLC is a common corporate entity that people create. It stands for Limited Liability Company. It means that, broadly speaking, that the things that you do within the legitimate course of your business cannot, impact your personal assets. Meaning that, if God forbid somebody were to sue you because you went on Twitch and you defamed their name, and, caused them to lose money, whatever, right? It's, then they might come after you. But if you were acting within the role of your business, then they can't, try to repossess your house or your car or any of that stuff. So creating that limited liability structure puts all of your business stuff on this side and protects your personal assets. It is not a bulletproof way to protect your personal assets. There are some legal mechanisms that can be used to kind of break down that wall. But it is your first layer of protection among others, like an insurance policy, right? That would be another way to protect yourself. The other reason why you might want to start an LLC is to mitigate your tax liability, right? You're going to owe taxes no matter what. One way that creators can, I think, really put themselves in a good position, and I will disclaim what I'm about to say by saying I'm not a tax lawyer.
Oh, nothing in this has been legal advice, by the way.
Yeah, none of this is legal advice, but especially not tax legal advice. Is that, if you are taking in money over the course of a year, that content creation or whatever your commercial business is sustaining, your life, helping you pay your bills, do not forget to set money aside for taxes. If you don't have an LLC, you are at the very minimum subject to the 15% self-employment tax that gets paid to the IRS, and then state income taxes on top of that. Another way to kind of structure it is to, if you are your own boss, then you might set up an LLC and make yourself your only employee, so that as money comes into the business, the first thing it does is go to pay your salary. Right? And embodied within your salary that you're paying yourself, you are also covering your Social Security and Medicare taxes, because if you are not paying into Social Security, you are not going to get Social Security. And I really do fear that in a generation that grew up in the gig economy, that so many of us are not going to get Social Security because we never actually paid into it. And if you're wondering whether or not you are eligible for Social Security, when you turn, 62 and a half or whatever, You can actually go to the Social Security Administration website and look up your account. Yes, you have an account that you can access, and it'll show you what your reported earnings have been throughout your wage earning years, and how much based on your employment history you can anticipate receiving as Social Security. Now, Social Security should never be, your only retirement strategy, but it is one of them. And if you guys are not paying into it, you may be disadvantaging yourself when you are older, right? And look, when I was young, I was not thinking about this stuff. I did not care. I had no concept of time, but you will get old, okay? And when you do, how are you going to sustain your lifestyle? These are important things that, if you're even in your early 20s, you should be thinking about, because the money you invest now in your retirement is going to be worth, compounding interest more when you get to be retirement age. So there are lots of good reasons to set up an LLC. Liability and taxes are two big ones.
All right, and by the way, lawyers have lawyers too, right? I have hired lawyers for various reasons in my past. But, no two lawyers are the same, right? You could ask two lawyers the exact same question and say, what is your legal analysis? And you will get two completely different answers. Okay, that's just the nature of the law. It is not black and white. It's a whole area of gray, right? And you just kind of got to operate within the unknowns, and making a lot of assumptions and hoping for the best. That's what legal advice ultimately really is. It's like an insurance policy that you hope you never have to use, but you'll be glad you have it, when you do need it. Sometimes I really do think it comes down to, personality compatibility, right? I've met some entertainment attorneys in my life, and I don't even like them. Right? We're all different. We're all unique. We all have a different vibe, a different sense of the universe and what we're doing here. So even just going around and calling people, coming to events like this, meeting with different attorneys, and just finding who you really click with, right? Who also is confident in what they're trying to do for you. I'd say the best time to reach out to an attorney as an attorney is when there's an actual deal on the table, right? And it's fine when people reach out to me and they say, hey, I'm cooking on something, I think I might need you soon. Is it okay if we have a little intro call? I say, absolutely, no problem. But there's not much I can do to say, okay, here's my engagement offer. I'm going to do X, Y, and Z for you if there's not an offer on the table yet. Maybe you are planning to make an offer to someone, like you want to hire a contractor to help you create your video game. We can talk about that now, but I won't be able to do anything for you until you commit to putting something in writing. Same thing on the other side. If you were anticipating receiving a deal, say you're being hired by a video game company to do some, Twitch streaming for them. That's great, we can get to know each other now, but I can't really do anything until you receive the offer and send it to my inbox so I can actually see it, legitimate it, and work on it. So there is no bad time. I'd say, in fact, the earlier you start thinking about these things, the better.
Yeah, let me again do the real world example. My company, AshSaidHi, our first game was called Battles of Destiny, published with a company called QQP. Got the contract, went to the lawyer. By the way, the way we vetted the lawyer was the one who was most upfront about the fees, and we felt had the most integrity, so I went with him. That's lasted us 30 years. We were very fortunate. But I'll love Beth to give more criteria for how you vet an attorney. But anyway, so one of the first things is, all right, well, let's add a clause here. If QQP goes out of business, all the rights revert to you, because they had the rights to distribute it. So sure enough, QQP went out of business. All those rights reverted to us without argument, because our lawyer put that in there, and that game from the early 90s is bringing us royalties now in 2024. What should probably happen was more lawyer involvement on the early partnership agreement before I got involved in it, and that would have helped out a lot. Yeah, if you're working with other people and your company have a partnership agreement in place, and that's a really good place to have an attorney. With Zeus, in Zeus Games LLC, my recommendation is, well, most game devs have the intelligence to create a business with no problem. They can look online, they can register with the Secretary of State's office, they can create an operating agreement for themselves, go with basic LLC terminology. But let's say Zeus Inc. doesn't want to waste brain power on that. I think it's a great thing for game devs to focus on what they want to do and not focus on the garbage they don't want to do. And they say, well, I want to have a publisher come in, and I might want to structure this to get investors in addition to publishers, or other than publishers, or maybe I want to have my intellectual properties held by one entity so that I'm only talking with a publisher about the distribution rights, and they're never going to be able to touch my actual ownership of my idea. So if the users don't want to research it, have to go try and figure all this stuff out. But the very first part, that's a great stage to already be going to the attorney and just getting that template out there. I mean, that early stuff is not expensive and can save so much hassle down the line. And if there are two of you, I recommend the attorney right now.
Thank you.
Susan Hera.
Yeah.
So there's two things that I heard in Andrew's comments that I think are worth highlighting. Number one is the partnership agreement that you have with your co-creators, right? If Ash is creating a game entirely on her own, she's good to go. She doesn't need a contract with anybody because she's a one-woman show. If you have more than one partner, and you agree that as between you and your partner, you're going to start an LLC, there are documents, like for example, an operating agreement that serves as the governing document as between me and Ash. And again, we're going to bring in Tygarlily as our third partner. Okay, so who gets to, some of the things in that operating agreement will be, okay, what are the assets of the company? In this case, we're all going to agree that all of our contributions to the game, that all of that intellectual property we're going to allocate to the new LLC. That is its primary asset in the way that the company that's owned by all three of us are going to make money, right? And then we have to decide, well, every company needs some cash to get it going, right? How much capital are we contributing to get this game off the ground, to keep developing it, to market it, to cover the costs associated with generating relationships. Maybe we have to fly to New York. Okay, who's paying for all of that, right? Well, hopefully the LLC is well-resourced to be able to do that. Every company needs money to make money, right? So we're going to decide through that operating agreement how much money we're going to put in. Well, what if we run out of money, right? What now? Do we all have to put money back in? Maybe, if I'm the deep pockets, I'm going to end up putting a loan into the company, and then as money comes in, as the loaner, I'm going to get paid back first, right? These things are always considered in the contract. Also, coming back to what we talked about before is the corollary to a prenuptial agreement. What happens if we want to dissolve the company? Or, what if Tygarlily says, hey guys, I'm moving to Hawaii, I'm going to live on a beach, right? If we don't have something in the contract that dictates what happens to her third of the company, then she will still own it even if we never see her again, right? And this really happens, right? We'll start a company with a friend and then all of a sudden they take off and they don't deliver what they promised they were going to deliver. And, I've seen a lot of operating agreements where there are, consequences to that. And I really think that that's a mistake because it can leave a company and a piece of intellectual property in limbo if the operating agreement also says that any decisions made about the company have to be made unanimously among the partners, right? How do decisions get to be made about the company and the asset that it controls, right? Is it majority vote? Is it unanimous? Are you guys going to appoint me as the manager and I just get to make all of the decisions? These are the material deal points that can go into an operating agreement that can really affect the long-term success or failure of the company. And look, I know a lot of this stuff seems a little bit out there if you're young and you're really kind of have a creative mind and you don't like to think about this stuff. I get it. That's why I'm here, right? I take this bundle of stress off of artists' shoulders so that they can focus on being an artist. But in exchange, what I encourage each and every one of you to do is to think about yourself as a business. You deserve that. You deserve all of the same protections that every other business owner in America, whether they're selling music or gasoline or technology, whatever it is. There are rules to the road. You just got to learn them and learn how to drive on them.
thread, and you'll never know what issues are in your partner's head. AshSaidHi is creating art for the game. She might be wanting to create an art book of all her own creations. She doesn't realize she has assigned all rights to this company, and now she has to get permission from her partners. So maybe that's negotiated early on. Tygarlily's laying down some awesome beats for it. She wants to have the soundtrack out under her name, but that's now in the company. So there needs to be another agreement about that, if that's a matter. And she has no idea that Tygarlily wants to release the soundtrack. Tygarlily's got no idea she wants to release the art book. And this is what you find out when you're negotiating that agreement. So last question before you open it up. What should we be looking for in a lawyer?
Good question. Everybody's needs are different, but number one, you should find somebody who is competent in the area of law that you need. So if the neighbor of your aunt is a real estate attorney and she's the only attorney that you know, they are not competent to advise you on intellectual property. Okay, unless they have a dual practice in real estate and IP, then same reason why I would not.
Do you know anyone who has that?
I think literally one. I wouldn't ask a tax attorney to handle my divorce, right? We all have specialties that as an attorney, as I focus on, these niche practice areas, for me, again, it's music, film, television, book publishing, theater, gaming, esports. This is stuff that I spend years learning about and learning the language and the customs and the industry and, just getting embedded with the culture of the people that engage in these commercial activities. So number one, competency in the specific subject matter that you need, okay? Fees are always a sensitive topic because lawyering is not cheap. If I, do a bad job for a client, I can have my bar license revoked, right? So there's an enormous amount of liability for me as an attorney when I agree to take on a new client. So it has to be worthwhile for me, okay? That's in part why lawyer fees are so high. It's because we have to deal with the liability of the services we provide sometimes too. The fee structures for lawyers varies, right? So don't be afraid to ask in detail what the fee structure for a lawyer is. Some ways that lawyers operate are, number one, through by charging by the hour, right? We charge in units of time most of the time. Time is money in the legal industry. So the more time you need to accomplish your goals, the more it's going to cost. Ask the attorney straight up, what is your hourly rate? So hourly and that can be coupled with a prepaid retainer. So retainers are a prepayment of services that sits in a legally protected account, and that money does not get paid to the lawyer until the services have been rendered, and then the cost of those services gets deducted from your prepaid retainer. In most cases, a retainer is refundable, so if you give a lawyer a $5,000 retainer, but you only use $2,000 worth of services, $3,000 remaining dollars can be refunded to you. This is how most retainer operations work. Some attorneys will offer their services on a flat fee basis, right? So you say, I need you to review this publishing agreement for me. And they'll, if that was me and I was operating on flat fees, I would say, okay, send me the offer. I kind of glance through it, get a sense of, the scope and the quality of the offer and say, I estimate this will be about, $2,500, right? So you go in knowing exactly what the cost of that is going to be. I used to do that. There were a couple of clients of mine that squeezed me through those flat fee deals and ruined it for everybody else. So I haven't done it in a while. I wouldn't be opposed to doing it again, but in that case, what a lawyer is essentially hedging is that whatever fee they quote you is actually more than what it would actually cost if you were paying an hourly rate. Okay, and then there might be a hybrid situation where the attorneys say, okay, I will create a contract for you for this flat fee, but if the person that you're proposing the contract to comes back and wants to make changes, well, any changes that attorney gets involved in then are then charged on an hourly rate basis. I have no problem as an attorney being very real with the people who call me about what the cost of legal is going to cost, and it breaks my heart when people come to me and and I say, hey, what you're asking for is going to take a lot of time, a lot of specialized expertise, and I tell them the retainer for that's going to be $5,000, and they were like, oh, I thought this was going to be like $100. Like, you just manage your expectations. I mean, like, go into it, knowing that you're going to spend the money, but that is going to be money well spent. Of your trademark application, but then also protecting yourself against potential trademark infringement, which is also kind of inherent in the registration process, where a trademark examiner, who is a lawyer for the government, is going to take a look at your application and then tell you if there are any immediate obstacles to you being able to move forward with your application. For example, if it is too confusingly similar to another existing trademark in the trademark registry, they will let you know. But there's also a whole research phase that goes into trademarks before you ever even file an application. And that's what a good lawyer can do for you, is go ahead and do that pre-search to tell you, like, hey, this is going to be problematic. There's already this well-known brand in the same category of goods and services that you're pursuing, so the best thing for you to do might actually be to rebrand. That is, not something that clients like to hear, but it also can save them hundreds, if not thousands of dollars in registration fees, in legal counsel, and fighting the other party once they come after you for filing a trademark registration that they stand to oppose. And so people don't realize that there's a whole legal structure that happens before you even file that application. So otherwise, uspto.gov is where you would go to register a trademark.
But go there anyway to search for the name of your trademark, because you can easy search as your first look. If you see someone else has already claimed it, you come up with a new name.
Yeah, it's one of the places that attorneys go to do that pre-clearance stage, but it is certainly not the only one. And I think an important reminder on that is that trademarks are granted, meaning exclusive use of a trademark are granted on categorical bases. So for example, if you hear the name Delta, right, we're in Atlanta, most of us are probably going to think of the airline, but Delta is also the name of a faucet company, right? Walk into
And dental.
Yeah, that's right.
Delta Dental.
Delta Dental, right? Yeah.
Different categories.
So yeah, because nobody's going to confuse the name Delta if they're searching for a plane ticket and then they accidentally end up on a faucet website. There's no consumer confusion in that regard, because these two companies are allowed to exist using what seems like the same trademark because they're in entirely different categories. So even if you find the name that you want on the trademark website, it's not necessarily preclusion of you being able to use it. That's where a good lawyer is trained to know where those overlaps exist.
All right, last question.
I have a question about Tygarly's question, actually. So you were talking about Kickstarter, and then you said you should contact the lawyer when a deal's reached. I was wondering if that a Kickstarter is considered a deal, because then it's like, oh, this amount of people need to pay this, and then I give them something in return.
So the question is, when you're starting a Kickstarter, would you consider that a deal that would require a lawyer?
This has come up on very rare occasion for me. I think a lot of the answers to that question might be buried in the terms and conditions on the Kickstarter website. Kind of setting Kickstarter aside, the way that I would describe a GoFundMe account is that it's gifts. It's gifts, right? There's nothing guaranteed in exchange. Kickstarter is a little bit different in that if you don't hit your goal, then the money never transfers, right? And at that point, if you are setting up a goal of raising $15,000 in exchange that you will give all of your donors early access to view your game, then at that point, it's really up to you to fulfill that obligation, right? Kickstarter is not going to follow up with you to make sure you did it. Your donors might, I've certainly given to, friends and strangers GoFundMe, and I never expect anything in return even if it's promised to me. Because there's probably some language buried somewhere in those terms of service that say, Kickstarter, it's not responsible for what happens after this. So in my opinion, it's really more of a brand management exercise than a legal one. But if a client came to me and said, hey, I've raised $1 million and I just need to make sure that I'm legally protected in how I set up this Kickstarter, that would be a very fact-specific analysis where I would go back and see what was it that my now client promised, and what are the requirements under the terms and conditions, what was said in the marketing materials on that page.
So Kickstarter will very rarely negotiate its own terms. However, the stuff you're putting up there, you want to have the trademark already done so no one's swiping it. I'd recommend as soon as you're putting assets up there, you have protections in place. And I would strongly recommend being a legal entity doing it, not doing it yourself. So if anyone does come after you about fulfillment, they're going after the legal entity and not you. So,
Yep, good advice.
all right, let's see. Oh yeah, we're over time. Thank you.